It's historically been known or referred to as alimony, but here in Kentucky divorce cases, we're talking about spousal support, or what is called spousal maintenance. Who gets it, and when, and why? Hi folks, Ryan Reed here with Reed Law Group. Of course, divorce is not only a significant life transition, but it layers the usual emotional complexities with some very important financial considerations. One of the most frequently discussed and often misunderstood aspects of divorce is spousal support, which we now call spousal maintenance here in Kentucky. I want to provide some clarity on what maintenance entails, who might be eligible, and the factors that influence its determination. My hope is that understanding these principles can bring a sense of clarity during a challenging time. Spousal maintenance is a payment from one spouse to the other after a divorce. It's not automatically awarded in every case. Instead, it's determined based on specific legal criteria. The underlying principle is to provide financial assistance to a spouse who has a need for support after the marriage is dissolved. This need often arises due to disparities in income, earning potential, or the contributions made during the marriage. So, when might a court award maintenance? Kentucky law outlines specific circumstances under which a court would tend to award maintenance. It's not about punishing one party or rewarding the other. It's about addressing a legitimate financial need that arose from the marital relationship. A judge will consider awarding maintenance only if they initially find two things to be true. First, that the spouse seeking support lacks sufficient property to provide for their reasonable needs. And second, that the spouse seeking support is unable to support themselves through appropriate employment. In terms of lacking sufficient property to provide for their reasonable needs, this means that their own assets, whether acquired during or outside the marriage, are not enough to meet their basic living expenses. Here, we're usually looking at substantial investments, accounts, or savings, or maybe income-producing property or a business of some kind. When we talk of being unable to support themselves through appropriate employment, there are a few reasons why a spouse might be unable to support themselves in this manner. They may have primary physical custody of a young child or one whose condition or circumstances make it appropriate that they not seek outside employment, or they might lack the marketable skills and capability to become self-supporting through regular work. This often applies to spouses who have been out of the workforce for a significant period of time to raise a family. Finally, it could be that they're physically or mentally unable to support themselves through gainful employment. If a judge finds that a spouse meets these two eligibility criteria, the judge will then consider a number of factors to determine the amount and duration of the maintenance. These factors aim to ensure fairness and take into account the unique circumstances of the marriage. The judge will look at the financial resources of the spouse seeking maintenance, including their separate property and any property they receive in the divorce, as well as their ability to meet their needs independently. The judge will also consider the time necessary for that spouse to acquire the education or training they may need to find appropriate employment. The judge will consider the standard of living established during the marriage. The idea here is that a divorced spouse should be able to continue living at or near that same standard of living if resources are available to facilitate it. The duration of the marriage is also a key factor, as longer marriages often lead to a greater likelihood of maintenance and for a longer duration. The age and physical and mental health of the spouse seeking maintenance are also important, as these factors can impact their ability to become self-supporting. The judge will also, though, consider the ability of the other spouse to pay maintenance while still meeting their own needs. The idea is to make sure that the paying spouse is not being unduly burdened. And finally, while Kentucky is a no-fault divorce state, the conduct of a party during the marriage can become a factor. For example, marital misconduct, such as adultery or abuse, can potentially influence a judge's determination of whether to award maintenance to the spouse who committed the misconduct. It's crucial to understand that there is no automatic entitlement to spousal support in Kentucky. Each case is evaluated individually, and the judge has very broad discretion. Also, spousal support can either be short-term or long-term. It could be temporary, just to allow a spouse time to become self-sufficient, or in some longer marriages with significant income disparities, it can be more long-lasting, though rarely truly permanent. Finally, spousal support orders can sometimes be modified in the future if there is a substantial change in circumstances, although the truth is it is exceptionally hard to do so in most cases. This issue of spousal support can be a significant source of anxiety during a divorce. Whether a client is concerned about potentially paying maintenance or understanding their right to receive it, having a clear understanding of this issue is essential. And hopefully I've been able to provide here some guidance on that subject. That's all for today. Stay safe, and thanks for listening.